All right, let's see. So I was perusing YouTube, and I'm very interested in trials in general, but mainly this Alec Baldwin trial, because this is the first time I can remember a like I don't know if he's washed up, but he was big time actor at one point. You know, he's kind of washed up now, but I mean, he was a big time actor at one point, and you know, he's on trial for murder, and you don't really see that. I mean, you don't really see these Hollywood guys ever really having the rules put to them the way that they're put on everybody else around the country. So I'm gonna listen to this, gonna comment on it, and please member up, hit that subscription button, subscribe, super chat, super thanks, do all that good stuff. Thumbs up. Let's see what they got to say here. Give me 1 second. I got to get the volume. I got to get the volume turned on for this thing. This is not a boomer moment. This is just me forgetting to actually turn on the volume. So, all right, hide this. Unhide that. And let's see here. We have monitor and output. That's good. Let me hide all. Hang on a second. All right, hide this, unhide all. All right, we can hide the capture card for now because we're not using the capture card. Maybe it's frozen, actually.
Excluded, and the defense, after full briefing of the case and in reliance on that position, the defense then conceded the state's the relief that the state had sought as to 5 of the 9 witnesses that the state was looking to have excluded. So the state was successful. In its motion, the state tries to indicate that that in fact a party must have already had the matter adjudicated by the court in order for there to be a successful position that was taken by the court. I'm going to go to the state's motion. And so what the state says is that this must have already been adjudicated by the court in some way through some order by the court. There have been no arguments, is what the state says. The state says the record in this case is crystal clear. There were never any hearings or other judicial proceedings in which the state's initial motion to exclude certain defenses was adjudicated by the court. And therefore, their position is that that means that there was no, that we don't meet the first prong. However, that's incorrect, Your Honor. And if the court will look at the case that we cited, and it's Kuchan, which is a 2024 case, the site is 2024 NMCA 032. And when we look at this case in paragraph 14, the court notes that the respondent in that case did not successfully argue and therefore assume this position in a motion or at hearing. So the use of the word "or" clearly demonstrates that a party can assume a position either by its argument through a motion or also by its argument at a hearing. So it's either or. It doesn't have to be at a hearing. It can also take a position through argument in a motion. And this is further solidified through paragraph 16 of the same case. In paragraph 16, the court continues and states that the respondent could not be considered to have successfully assumed a position about the nature of the West Track until filing the motion for partial summary judgment. It doesn't say until argument of the motion. It says that upon filing of the motion for partial summary judgment, that is the moment at which the respondent could be considered to have successfully assumed a position. And that is what the state did in this case. They assumed a position in the motion that they filed, both the primary motion and then also their responsive briefing. They assumed a motion, or I'm sorry, they assumed a position. And they successfully
Doesn't
assumed
make
that
sense.
position because the relief that they sought was granted effectively by the defense consent to that relief. The second prong, Your Honor, has and I will actually point out the cases that the state cited for this principle. So that was the one that the defense cited. The state cited 3 cases in support of their proposal that that a motion has to be argued before the court and there has to be an order in order for there to be a successful assumption of a position.
Well, yeah,
They
you have to
cite
put a motion before the court.
O'Brien, they cite the Gabriel V. Hill case, and then they cite a 2014 unpublished opinion, which is non-precedential. So I'll go over the 2 cases that are actually published case law. For O'Brien, in this case, this is a case where the court did apply judicial estoppel, and there did happen to be an order that was entered by the court. It was a pretrial order, but merely finding a case where estoppel was applied and where the court had entered an order does not indicate that the first prong can only be met where the
Well, but like, was that guy, did that case have the same sort of public scrutiny that this case has? I mean, did that guy get stopped, or woman? I don't know if it was a guy or a woman. Did that like person get stopped in coffee shops, and harassed? And now, I'm not an Alec Baldwin fan. I'm just stating facts. He was stopped and harassed by this lady. Not this lady, but a lady. But like, I mean, and I don't know. Let's continue to listen, but like, I don't think there was an estoppel either. I mean, like, there was nothing preventing them from arguing their case. There's been nothing so far that's been stopping these folks from arguing their case. I mean, if anything, they can probably argue their case easier being that Alec Baldwin's such a huge public figure. And there's a lot of interest in this case because of the way that this woman died. I mean, it's horrible getting shot on a movie set with what's supposed to be a blank and it's a real bullet, and everybody's blaming everybody else. I mean, somebody had to put that bullet in the gun.
court has entered an order, and that is not the holding of the case. It just so happened to be that in that case, there was an order that had been entered by the court, and therefore that met that part of the prong in the either or. So either in a motion or at a hearing. And so in this case, there was a hearing that was appropriate, but that does not say anything about the fact that one can also take a position through a motion. The Gabriel V. Hill case, this one doesn't even deal with judicial estoppel. It actually involved the doctrine of collateral estoppel, which is a different doctrine. So collateral estoppel has a different test than judicial estoppel. And the purpose of collateral estoppel is to promote judicial efficiency and consistency. And the goal is basically to keep parties from relitigating issues from a previous suit. With judicial estoppel, we're talking about a purpose that has to do with protecting the integrity of the judicial process by preventing the parties from, and this is quotes from the various cases, from playing fast and loose with the court and ensuring that the party does not manipulate the judicial system. So in light of the fact that there is a 2024 case, which is the case that the defense cited, that precisely states that a party can assume a position pursuant to the first prong through motion alone, the question again is whether or not they were successful, and we submit to the court that they were.
Why does she keep talking about an estoppel? Like, here's the definition of an estoppel. I'm reading right off the internet. Simply put, an estoppel prevents one person from contradicting an action or statement from the past. Well, if she's talking about an estoppel from this previous case, then what case is she referring to that this estoppel was based off of? Like, so far, this lawyer sounds like an idiot. Maybe Alec Baldwin's broke and he can't. Maybe she's a public defender. I don't know. Well, let's continue.
Now, moving on to the second prong. The second prong says that the first position is necessarily inconsistent with the position that they take later. Clearly, that is the case. Clearly, that has been met. The state was first saying that there was prejudice by the inclusion of these additional witnesses on the defense witness list. The state's position was that those witnesses should be excluded. And now they have taken the exact opposite position, saying these witnesses should be able to be called by the state and there is no prejudice by their inclusion. Now, even though only the two prongs are...
So is that what she's referring to as an estoppel because the state contradicted what they said before? I mean, are people not allowed to change their mind after getting, if you hand somebody a witness list and there's however many people on this witness list and you at first say, we don't agree with this witness list, but then you do some digging and you do some research and you find out more about these people and what they can offer to help your side, then you change your mind. You can do that. The trial hasn't started yet. This is all pre-trial stuff. The trial's not supposed to start until July 10th. So far, this is a dumb argument.
Actually required. The third prong, again, indicates that if the party's change of position prejudices the party who had acquiesced in the former position, then judicial estoppel will be especially applicable. And that is the case here. So the defense relied on the state's motion, which the state had told the court on May 31st in their notice of completion of briefing was fully briefed and was ready to be heard. And in recognition of that fact, and recognizing that we are scheduled for trial for 8 days, in an attempt to pare down our witness list substantially, we removed, again, almost half of the witnesses from our witness list, revealing significant defense strategy. And we also informed our witnesses. There were some witnesses who were scheduled to be interviewed the following day and then a couple of days later. We informed those witnesses that they were released from their subpoenas. And we did, in fact, release them from the subpoenas, and we told them that those interviews would be canceled. We sent, again, courtesy copies of our notice to the state along with our amended witness list. And then that's when, within less than 3 hours after seeing defense strategy, the state changed its position. Now, the state proposes that really they can just cure any prejudice to the defense by extending deadlines. But that doesn't cure our prejudice for a variety of reasons. Primarily, because you cannot cure the fact that we have already revealed defense strategy in reliance on the state's position, and the state has now walked that back. We cannot cure that. In addition, we're in a time crunch at this point, Your Honor, and we do not have further time available. The state, in their...
You've had a long time to get your shit together. Claiming now that you don't have time, that's no argument. You've had plenty of time to get this together. Plenty of time. This is like a 5th grade argument. It's crazy. What a bad argument. You've had plenty. Now that you're claiming you only got 8 days, this sounds like Darryl Brooks. When Darryl Brooks was saying, I just got this big box of stuff. Maybe I'll play that after this. After this, we'll do a Darryl Brooks breakdown. The Darryl Brooks trial is the best trial I've ever seen. But he was claiming that he had no time to prepare. Well, all that shit was done for him. It was all boxed, neatly organized. It's the same type of argument. I had no time. You had plenty of time.
Motion on May 6th noted that that they were prejudiced by the fact that there was only 8 weeks prior to trial. We are now in the position where we only have 2 prior to trial. We did not receive significant information from the state previously, and the reason that that is relevant here in particular is because time is a finite resource. The recordings alone that were disclosed related to Hannah Gutierrez Reed are so significant and substantial that if we take an average of the time that it would take to listen to each of the calls, and we dedicated one whole person doing nothing else, taking no breaks for a full 8-hour day, it would take that person approximately 15 business days to listen to the recordings. But we don't have 15 business days, we have 10. And not only that, we also then have to look at the potential of having to interview Ms. Gutierrez Reed. So time at this point, Your Honor, is a finite resource, and the state is playing games to exploit that resource and to take time away from the defense where we should be spending our time in trial preparation. Instead, we are having to deal with the state's constantly changing positions, with their changing disclosures, with the new things that they're adding.
So the way I'm understanding this, now I'm no lawyer, but I have a lot of lawyer friends. I've been around the law a long time. I'm pretty up on a lot of things. Like I can have a conversation with pretty much anybody and sound like I know what I'm talking about. The way you're arguing right now, this lady, it sounds like there's 1 or 2 people on this team that the state is throwing so much shit at them that it's absorbing their whole team. I find that very hard to believe. There's probably Alec Baldwin's probably got a huge team. They probably have, pre-law. They probably have law students working for them. They probably have all kinds of, folks on their team helping out that can, rifle through these different motions and the different things that the state's throwing at them, while the main trial lawyers can still kind of focus on everything else. I find this is a really shitty argument that the state is throwing. It's like, the state's throwing so much stuff the state is throwing that these lawyers can't do their job, because how many motions could the state really file? How much stuff could the state really throw that has taken their whole team off of trial preparation? They've had months and months to prepare. Now, if this was one person on this team or two people on this team, I could understand. He's probably got a couple different law firms working on this. There's probably a good 10 to 15 people working on this case right now. This lawyer. So this is the kind of attitude you get when your parents don't tell you no when you're growing up. When you're growing up and your parents are always saying yes to you and telling you how good of a job you're doing, and nobody ever says no to you. This is the kind of attitude you get, where you think you can just say anything and people will buy it.
And it's fundamentally unfair. And as the state notes in the state's own words, calculated sandbagging is not appropriate. And what they say in their own motion is that they say this kind of manipulation of the courts should not be permitted, and we agree. And so we are asking the court to therefore exclude the witnesses and to grant the defense motion.
All right, let's see what the other side's got to say.
I have a couple of questions before I hear from the state. First, you talked about that you decided that you were going to limit your witness list, cut it down because you had to switch gears for trial preparation. The time for investigation was superseded by preparation. If I'm misstating that, tell me right now.
No, Your Honor, that's correct. That is a big part of the consideration as well, which is why we were assessing our case in that moment to determine what needed to be done.
And so you said that you made this strategic decision, and that
Get her, Judge.
but I'm not clear, and that they know what your strategic decision is. Is it anything more than you eliminated a witness?
No, Your Honor, we did not include any additional dialogue with the court or information in the pleadings, but again, we had pared down our witness list to almost half of what it was. And so I think that gives the state a pretty good idea of what we're going to be doing with the case.
Okay.
Mm-hmm.
And so then you're talking about this sort of bait and switch is what you're saying, where on May 6th, they had a problem with your witnesses, and then on June 2nd, you took certain ones off, and then on June 2nd, they added 3 of the witnesses that you took off. And I'm not quite sure how that short time frame.
See, that's what I said. You've had months.
I know you're arguing a little more than short time frame, but that's quite a short time frame, right?
A short time frame for what? I'm sorry, Your Honor, if the court would clarify.
For them to have added the 3 witnesses that you deleted.
Correct. Yes, it was a quick turnaround. Right. That is correct. Within
and how do you explain that they have always added at the end any witnesses called by the defense, and that you had these individuals on?
Mm-hmm.
That's correct, Your Honor. And so it's a different position, I think, than we would be in if, let's say, the state had not filed a motion to exclude. That's the part that changes, I think, the analysis in this case, because at any point, of course, one party or another can remove witnesses from their witness list. We could not add any more witnesses based on the court's order, but we could remove witnesses from our lists. And there was the catch-all of, any witnesses who were listed by the defense or by the state, and that is correct. However, what's different about this particular situation than the typical instance in which a party may just decide to go ahead and remove witnesses is that we did so in advance of the final trial witness list, for example, that this court has, which I believe is Monday. And so we did so in advance of that in order to say, okay, we're not even going to finish doing these other witnesses. We know where our case is going to go. We're pulling these people off, and this is what we're going to do. And we did that in reliance on the briefing that was filed by the state. And so it's a bit of a different position because the state had already effectively indicated to the defense as well that they did not intend to call those witnesses by moving to exclude them. You can't move to exclude witnesses from trial for the defense, but then be keeping them for the state. That's
Yes,
not what they were saying in their motion. So what they were saying was these witnesses should not be called at trial. And so they're saying that they also will not call those witnesses. We then in reliance said, okay, fine, we agree to not call those witnesses. And so this is a different position than one party unilaterally just removing witnesses from their witness list because it was done in reliance on the state's briefing and on their motions.
So the prejudice is what?
So the prejudice
went into this whole thing that is not in your.
Even the judge is confused.
More of your Brady violation motion. So what's the prejudice?
So the prejudice at this point, Your Honor, is we already had canceled and released witnesses from subpoena. So they were no longer valid subpoenas since we had already informed the witnesses that they no longer had to be there. The witnesses, even though some of them had already been interviewed, the problem is, and again, we don't want to go through an analysis of what each of the witnesses would be because we're not going to reveal further strategy to the state than we already have. And so we're not going to do an analysis piece by piece, to tell them what the import is or is not of each of the witnesses. But suffice it to say that we did an analysis of these cases as a group, as a whole, could be released and could be removed from our witness list together. If only some of them are now coming back, then that can again impact whether or not there need to be other witnesses who would still remain on the list whom we have not interviewed. And
she's making no sense at all.
We can just extend
I'm so glad she's not my
the deadline, right? We can extend the deadline to take care of that issue. That's the state's proposal. But again, we have a finite amount of time and we are in full trial prep mode at this point.
Should have been in full trial prep mode for months now. You should be ready for trial. You got 8 days.
3 more witnesses because you might have to interview some additional ones.
And that's the thing is we made a decision and a call based on whether or not we might need additional witnesses. That's correct. Beyond that, but at this point, we don't have the ability to do that, and so that's the prejudice.
So the prejudice is that you're preparing for trial and you can't do these pretrial interviews. You need to articulate it for me.
Of course, absolutely, Your Honor. So that is certainly a part of the prejudice, and so it's multifaceted. So that is a part of the prejudice. The other part of the prejudice that is specifically related to the witnesses is in releasing or removing nearly half of our witness list. We also, again, some of these witnesses are interconnected, and so now we have removed 11 witnesses, and the state is now adding back piecemeal, which witnesses they want to put on. And it happens to be some of the ones that they had moved to exclude. Those are the ones who they've listed as being added. And so the prejudice is that it does impact our case and our presentation.
And then your judicial estoppel is talking about fast and loose, but you're also that, they took one position, then they took another position, but you're talking about all in the same, I don't know, what is it, 48-hour period? I mean, they added them and then did their withdrawal, and you're talking about that constituting judicial estoppel?
Yes, Your Honor, because it wasn't just that one moment either. It was the fact that this had been briefed over the course of a month as well, and the state had indicated that the briefing was completed. And these witnesses In particular, they were very difficult for us to serve as well. We don't know that we would be able to get them back. We had difficulty serving them through our process servers, and they
This
were
judge
hard to find.
is so
And then there was
confused by
also
what
one
this
who
lady
was
is saying.
released who was actually an out-of-state subpoena witness, and those also take additional time that we don't have at this point.
Appreciate it. Thank you.
Yes.
I don't know who's going to be
What a
arguing.
stupid
It's
argument.
me, Your Honor.
Okay.
Thank you. May it please the court. Your Honor, the case that actually governs this court's analysis is State versus Harper. And in State versus Harper, the New Mexico Supreme Court at 211 New Mexico Supreme Court 44 paragraph 2 noted that exclusion of witnesses requires an intentional violation of a court order, prejudice to the opposing party, and consideration of less severe sanctions. And when considering sanctions, prejudice to the opposing party is a central consideration. And in Harper, at paragraph 19, the Supreme Court noted that even when a party has acted with a high degree of culpability, the severe sanctions of dismissal or exclusion of key witnesses are only proper when the opposing party has suffered tangible prejudice. And in this case, Your Honor, first, I would submit to the court that prosecutorial discretion allows the prosecution to make decisions with regard to the evidence it plans to present at trial. Unless bad faith is
And you know, court cases are fluid. They're continually moving. New information comes out. Something now that they couldn't use before is usable. You know, the fact that the defense excluded witnesses, which was their choice, and now the state is choosing to use those witnesses. Well, that would make sense, wouldn't it? Like, the defense is only going to exclude a witness if it stops them from winning the case. So, of course, you're going to exclude witnesses that hurt your case. But if it hurts your case, that means that it helps the state. So why wouldn't the state go after these witnesses? I mean, somebody should have told this girl no more when she was growing up. Let's hear what the state's got to say. Oh, wrong button. Boomer moment. Sorry.
demonstrated, those decisions are generally not subject to review. I would submit to the court that in this case, what happened, Your Honor, is that on May 6th, there were a number of witnesses disclosed. Because that was the pretrial motions deadline, the state had no idea the defense was planning to call these witnesses. So we filed this motion. But then these witnesses were set for pretrial interviews, the ones that the defense now seeks to exclude. These witnesses were interviewed. These witnesses, then the state investigated the statements of these witnesses and determined over a period of that weekend that it would be there would be no prejudice to the state. So we went ahead and withdrew the motion. And so what's important for the court to know, Your Honor, is that Mr. Zach Sneesby, which is one of the witnesses that the defense fortuitously decided to withdraw, actually was interviewed the week before the last week in May. And during his interview, he revealed that he was standing very close to Mr. Baldwin when he shot and killed Helena Hutchins. And Mr. Sneesby specifically said he saw Mr. Baldwin pull the trigger. And as you know, the defense position has always been that he didn't pull the trigger. Well, now there's an eyewitness who actually says he saw him pull the trigger. And he said this during his pretrial interview. The state conducted additional investigation and determined that it would then withdraw its objection or opposition to these witnesses. There was no bait and switch. There was no bad faith. And what's important, Your Honor, is that these were defense witnesses. It's not like these were state witnesses that were not made available for pretrial interviews. These were defense witnesses. Presumably, the defense had spoken to them, had investigated what they were going to say, and they disclosed them on their witness list. So for them to now argue prejudice is, I would respectfully submit, disingenuous, because they are seeking to exclude and claiming prejudice because they withdrew and didn't have time to set up pretrial interviews of their own witnesses.
That's right.
Well, if we're going to list witnesses on our witness list, we first interview them, find out what their they have to say, and then we list them on our witness list if we believe their information or the evidence they're going to present is relevant. On May 6th of this year, the state filed its witness list. The 45th witness, as the court noted, is any witness disclosed by defense, called as a witness by the defense, or listed on the defense witness list. The fact that the state then listed the witnesses the defense sought to withdraw on its witness list does not result in a violation of the rule, because we did, as the court pointed out, the 45th witness was any witness listed or disclosed by the defense. Your Honor, with regard to the prejudice, because before the court can impose the severe sanction of exclusion, the court has to find that there is prejudice. At paragraph 19 through 21 of the Harper decision, the court specifically stated, and I quote, "The requirement that any serious sanction against the state be conditioned on a finding of prejudice is well established in our case law. Prejudice must be more than speculative. Therefore, when discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defense preparation for trial." These were defense witnesses, and that bears repeating. These were not state witnesses that the state suddenly disclosed a few weeks before trial.
Yep.
These were their own witnesses
Plenty of
that
time.
the state put on the witness list on June 2nd. Therefore, Your Honor, under Harper, I would submit to the court that there has been no intentional violation of the court's order. In fact, there has been no violation of the court's order, and therefore the extreme sanction of exclusion is not justified.
Mm-hmm.
The state offered and continues to offer. We will agree to extend the pretrial interview deadline. If they wish to interview yet again, potentially their own witnesses, we have no objection to that. We have no objection to extending the pretrial interview deadline. And that would be the appropriate remedy in this case, Your Honor. With regard to the doctrine of judicial estoppel, I would submit to the court, Your Honor, that this is a doctrine that would not be applicable in criminal cases. And
Right.
we cited to a case that could be analogous for that proposition, and that's State versus Arevalo. And that's 2002 New Mexico Court of Appeals 62 decision, wherein the New Mexico Court of Appeals refused or rejected the application of non-mutual collateral estoppel. And in that case, the New Mexico Court of Appeals,
Yeah, I like the
in
glasses look.
citing
all right with
Standifer
me.
versus United States, a U.S. Supreme Court decision from 1980, noted that the question whether the contemporary doctrine of non-mutual collateral estoppel basically is an unknown for New Mexico courts. Now, in New Mexico, with regard to criminal cases, the important interest in enforcement of criminal law and the public interest in the accuracy of justice of criminal results are not present in civil litigation. So what the defense is asking this court to do is to apply a doctrine from civil law to a criminal case. And we have different concerns, Your Honor. We have different concerns in a criminal case as we do in a civil case. And so as the court in State versus Arevalo rejected and refused to apply the doctrine of non-mutual collateral estoppel, this court must reject the defense invitation to apply this judicial estoppel doctrine to this criminal case. The state was not able to find any case where the doctrine of judicial estoppel was applied in a criminal case. And that's because based on Arevalo, the appellate courts in this state would likely reject the application of that civil doctrine to a criminal case. But assume even if the court were to consider applying judicial estoppel, the state respectfully submits, Your Honor, that the defense has failed to meet the requirements. First, the party against whom the doctrine is to be used must have successfully assumed a position during the course of litigation. Now, the defense argues that there need not be a judicial decision. The state submits to the court that that is a prerequisite. And even the case that they cite to matter of state of Kuchan at paragraph 14, the court specifically says, quote, under New Mexico law, a party successfully assumes or argues a position when the party takes that position before a judicial body, that position is at issue, and the party is ultimately successful. The Kuchan court cites to Wooten versus Vinson, and in that case, the court declined to apply judicial estoppel in a dispute over attorney's fees to the plaintiff's argument that the fees were reasonable, in part because the plaintiff did not ultimately convince the district court that her attorney's fees were unreasonable. This court had not yet ruled on the state's motion. So that prong of the judicial estoppel doctrine does not apply in this case. Counsel argues that, well, it's either a motion or they could have an order and the first prong is met. Given the language from the Kuchan case, the New Mexico courts, appellate courts would likely find and did find in that case that there has to be some judicial decision as it relates to the position that was taken by the party. But assuming the court finds the first prong is met, I would respectfully submit that the defense has failed to meet the prejudice prong. And the judicial estoppel doctrine requires the defense to establish that they have suffered prejudice. There has been no prejudice in this case.
That's true.
Again, these were defense witnesses who were disclosed by the defense, presumably interviewed by the defense, and that's why they disclosed them, because they obtained information that they believe would be favorable to their position. So there is no prejudice in this case, and we're talking a very short period of time. And again, prosecutors' pretrial decisions carry or enjoy a strong presumption of regularity. Unless there has been a showing of bad faith, those decisions should remain in place, Your Honor. There is no prejudice to the defense as it relates to this particular issue. And as I noted, Your Honor, under Harper, the decision here would be to extend the pretrial interview deadline, allow for the defense to speak to their own witnesses, and any prejudice is cured. And we would respectfully request that the court deny the defendant's motion to exclude these witnesses.
Yeah, I mean, they're valid witnesses. Just because the defense got rid of them, and now the offense is saying, I want these players on my team because now they can help my team. There's nothing wrong with that. Well, I mean, if this is Alec Baldwin's defense team, man, he's in for a long trial. It's going to be a fun trial to watch. A long trial.
Reply, Ms. LeBlanc.
Yes, Your Honor. I'd like to address a couple of the cases that the state has raised. First, with respect to Arevalo, State v. Arevalo. On this case, Your Honor, where they're talking about mutual collateral estoppel. Again, collateral estoppel is a different principle, but what the court was deciding in this case was there were two co-defendants, and they each had been assigned separate jury trial settings. At one jury trial setting, one of the co-defendants was found not guilty. Then the co-defendant who was set to go to trial second, then instead filed a motion for judgment of acquittal, asserting that because the other co-defendant was now found not guilty, that the same should apply to him. And so that was what the decision was, and the court found that there was a lack of mutuality. So this is a very different analysis than judicial estoppel. There is precedent, however, for the use of civil type doctrines or principles when we look at, for example, specific performance that derives from contract law. And we have cited cases in our motion as well that have to do with the proposition that when the state has made an offer of a plea agreement where the defendant detrimentally relies on that offer, even if it has not been yet accepted by the court, then the state has to engage in specific performance and leave that offer open. So there is precedent, Your Honor, for the inclusion of civil doctrines within the criminal context when it is appropriate. And in this case, it is appropriate in order to maintain the integrity of the judicial process. The other proposition that the state has put forth before the court was that basically criminal prosecutions and their discretion in initiating and conducting those prosecutions will not be disturbed, those decisions by the prosecutors. And for that proposition, they cited Blackledge v. Perry. And in this case that was cited by the state, actually the court did not say that the prosecutorial discretion would stand absent bad faith. They say the opposite. What they said was that even in the absence of bad faith, the state cannot indict on a felony after the defendant had been convicted on a misdemeanor and then appealed the conviction and got a trial de novo. And they said even where there was not bad faith, the prosecution cannot do this because, in fact, they don't want this to have a chilling effect on defendants who would be exercising their right to appeal. And so that is not accurate, that bad faith is the only way in which a prosecutorial discretion can be overturned. And I would ask the court to consider the fact, again, in the state's own words, in their motion that they filed on May 6th, the rules do not contemplate gamesmanship and this court should not countenance such conduct. I will also point out as a couple of final points that the state talks about, the time the defense had to investigate this case. However, the state has had even longer. The state has had nearly 3 years to investigate this case. And somehow within that short window of, less than 48 hours between when the last witness had been interviewed on May 31st and then the moment that the defense had filed had submitted its courtesy copies and filed its notices of withdrawal of witness and also its new amended witness list. Within that period of time, what changed? What additional investigation was had that didn't already take place before? They have told the court nothing about any of those specifics. What changed was that the defense revealed its position and then they sought to take advantage.
Okay, so
and
what?
in addition, the state says
What's wrong
that
with
they
that?
filed its
You're allowed to
motion
do
to
that.
exclude as a placeholder motion. First, in order to file a motion, there has to be good faith. You have to have an actual basis to file a motion. The state in their motion claimed prejudice. That is different than a placeholder motion. If they're saying it's just a placeholder, then how are they making assertions of prejudice if it's just something there? So it sounds like the state is saying that those are just words.
All right, Judge,
that they
cut this
included
bullshit
because
off.
that was
Let's
the
go.
standard that they needed to
Let's
meet.
go, Judge.
Rather than actually determining that they had suffered prejudice because it was merely a placeholder. So we would ask the court, again, to grant the defense motion.
Go ahead,
Thank you,
Judge.
Honor.
Do your thing, baby. Come on.
Thank you
Yeah,
for your
Judge.
presentations, counsel. The court makes the following ruling, which will be followed up by a written order. The court denies the expedited motion for order excluding witnesses.
There you go.
I did not think that the defense has demonstrated the prejudice that is required under State v. Harper.
Mm-hmm.
The defense was on notice that the state may call defendants' witnesses through their May 6th witness list addendum. And
Had
given this
notice.
notice, the court does not find that defendant was prejudiced by the later filed June 2nd, 2024 witness list addendum. With respect to the judicial estoppel argument, that also is denied as part of this order because the doctrine is to
Denied. That
prevent
is right.
parties from playing
Watching something
fast
about
and
the Alec
loose
Baldwin trial coming
with the
up.
court by successfully arguing one position and then later adopting a position inconsistent with the first. And there, I don't think you've met the prongs of, first of all, they didn't successfully argue before the court, and also I don't think that there's the prejudice.
If I'm still out of work by the time this trial starts, which I doubt I will be, but if I'm still out of work, then I'm gonna probably live stream this trial. Trying to branch out a little bit, James. Trying to do a little bit more than just aviation when I have the time to. It gets kind of boring just doing flights all the time, you know. I want to branch out a little bit and use my voice a little bit more instead of my flying skills. all them amazing flying skills I got. It's not amazing if you saw that landing last night. Hey, I think Chicago and I are setting up a little competition, a little friendly competition for like a landing challenge in the flight simulator, and we can post our videos on the Discord channel. So Chicago and I just started kind of talking about that yesterday, but I think that's going to be kind of fun. All right, I think the Darryl Brooks thing was during his 50-minute rant, where he was saying he didn't have time to go through the boxes. Let me see if I can. If you're not familiar with this trial, oh my God, this trial was the most fun I ever had watching YouTube. All right, so if you guys aren't familiar with Darryl Brooks was now found guilty. He's in jail for like 3,000 years or 10,000 years, something like that. He in Waukesha, Wisconsin, back in 2021, I believe it was. There was a Christmas parade, and he drove his mom's Ford Escape through pretty much the whole parade. He injured 66 people and killed 6 people. And all he had to do was just stop. But he didn't stop. He drove 35, 40 miles an hour through the whole parade, running over kids, adults, bouncing them off his truck. If you were to see the way the truck looks like it hit a deer, that's how much damage he did to his vehicle by hitting people. So let's see what... I think this is the rant that he did, where he said that he didn't have time to get ready for the trial. But let's listen to this bullshit. Now, he's a sovereign citizen. He decided to represent himself. Yeah, I'm going to listen to this. So this is fun. This is a fun thing to watch.
And I'll identify me by, I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client.
So he's saying that his name is not Darryl Brooks anymore. To give it a little context, because on some of the filings, his name was written in all capital letters. He's saying that he does not identify as that person, and he doesn't know who that person is. So he's trying to use this word salad to say that, he's a third-party intervener, and he doesn't identify as Darryl Brooks. And yeah, it's crazy, man.
Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later.
He seems to think that the judge needs to show him that, she has jurisdiction to rule this case. He wants to know if this is admiralty court, like a military court, or if it's a regular court. Like, he's trying to pull out all these sovereign techniques. It ain't working. It didn't work, Darryl. It's not going to work in replay, and it didn't work. Certainly didn't work. All right, let me stop yapping.
If I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just wait
jurisdiction?
till the jury's out, please. I ask that you show that respect.
I will.
Thank you.
The judge had to be a certain way during this because she was trying to make sure that he couldn't have a leg to stand on during appeal, because she knew he was going to be guilty. I mean, how can you not? I mean, he's videotaped and pictured in the vehicle driving over people. Like, he's definitely the one. You the one, Darryl. You definitely the one.
Everyone else can be, you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking, is
And on what
this,
legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me
You're not guilty. You're not guilty because you didn't get
office,
certified copies.
which you are required to
prejudice.
show if I ask for it. I've brought up my
You a
Sixth
fool, Darryl.
Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have.
Oh yeah, that's another thing he was trying to do the whole time. He was trying to say that this case should be thrown out of court because he can't face his accuser. Well, the state of Wisconsin is the accuser, but he's trying to say that he's getting criminal law mixed up with civil law. Civil law, you need to be able to face your accuser. Accuser needs to be a person or a business. Criminal law, the state represents the people that you harmed or you allegedly harmed. In this case, he did harm them. Back then, it was allegedly. But the people you killed, how are they going to file a claim, Darryl? The people you killed, the 6 people you killed, how can they file a claim? Man, you're stupid, Darryl. Just stupid. Whoever gave him this idea in jail, like when he was sitting in jail and somebody's like, hey man, you should just represent yourself. That's what you should do. Get rid of them lawyers and talk yourself. Just do it yourself. Say this, say that. Say I don't agree. Say I don't identify as Darryl Brooks. That'll get it thrown out. Don't throw it out of court because you didn't get certified copies.
Have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021, the amended complaint from November 29th of 2021, the second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor. I addressed that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity.
No, it doesn't, Darryl.
As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state-issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet.
Darryl.
There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up? I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. Mm-hmm. I can go on and on and on about what's not being done. I have again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything.
Somebody should have said something.
Which you
Nobody had
stated
the
for the
balls to
record,
say.
a
I would have said something if I was in there.
non-responsive
I'd be like, you killed
A
my son.
non-responsive
How can he
answer
make a claim?
Is an agreement, which would be a tactic agreement by you, Your Honor, that
It's tacit, you
don't
idiot.
have to answer these questions that you should be answering.
Not tack it.
I have that right.
Ain't no such thing as a tacket agreement.
The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Have that been placed in the evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth in their duty, in their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know.
Sure.
Once
Sure they
they were
do.
chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of.
But
It's
they're
our
informed,
right
all right.
to inform them of everything that they have the power to know, to do, and to know.
They informed that you drove your truck
deserve that
over
much.
72 people.
It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times, only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any
You wouldn't
plea
take
that
a
may
plea
have been
deal anyways,
suggested
Darryl.
by
Come on,
the
man.
prosecution. We haven't even,
Come on,
we haven't
Darryl.
even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days
Here we go. This it.
to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here.
He had three days. Bullshit. You're the one that fired your attorneys, and I believe you fired them so you could try to delay the trial. Because now you bringing it up. 3 days, my ass. Them attorneys got you all set. Them boxes are in order. They have all the information you need. Everything is labeled, dated, complete for you. 3 days. 3 days! You only had 3 days to prepare for this trial.
This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least at the minimum, it should be an adjournment because of that fact, at least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim? Who? I have the right to put the judge on notice of my intent to appeal in any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down.
Because your objections, we'll have to play another video with him because he objects to every single question that the prosecution asks a witness. He objects to, but the objections, they make no sense. It's not a proper objection. Like he doesn't know what he's doing. and it's more apparent every time like he opens his mouth. Like you can't object for grounds when this witness clearly saw you. You know what I mean? You can't say it's hearsay. You can't object and say it's hearsay when it's the actual person that's saying it. You understand? Like, you can't put into evidence, Darryl, a police report that a police officer wrote about what somebody else said and then ask that witness about it. You can't, like, you don't know what you're doing. You would have been found guilty anyways. But at least you made it fun for all of us to watch.
Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date, way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I can reach out immediately when I learn something. That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed, and how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a Detective Casey, that got on the stand and said on the record that is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being?
How are dead
So
people
where's the
supposed to? Come on, Darryl. You know this.
Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Would they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction.
You talking about jurisdiction?
That's been being asked for over a week.
She already gave you an answer. She gave you a written decision. You threw it out as soon as they handed
There's
it to you.
still
You threw
no
it out.
providing of license to practice law yet. Not even by you, Your Honor. Why was I not provided with a certified copy of your oath of office?
Mm-hmm.
Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it's not certified. So how can I verify that that is the true oath of office that you signed? How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why. I have the right to ask for that legally. I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant? You also know
Come on, Darryl, spit it out.
that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here. Every time. You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case. Nowhere does it say you can create a 4th option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office.
Treason.
Treason. You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down. Which leads to today. The constant push not to have an informed jury.
Informed them that you didn't get certified copies of your paperwork. Right, that
Not
makes
giving
sense.
legal, valid grounds on objections. Not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing a claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense. You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait till the next day. That's a clear bias and a clear prejudice to my defense. Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms.
That's not true.
I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement.
Tacit, Darryl, not tack it.
But yet, I'm still forced to come in here with zero help. I think it's clear that that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day. Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells.
You all right?
That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed.
The court has nothing to do with the jail.
To be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need.
You do. You got all your boxes and you got a tablet.
If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case.
Can't talk out of both sides of your
seeing
mouth,
as how
Darryl, and expect a good answer.
I only had a couple days to prepare for a trial of this magnitude.
That's bullshit. You had plenty of time.
Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident.
Yeah. But what does that got to do with the...
There's still...
Hang on a second.
Talk throughout the jail.
The jury is sequestered during this trial. They have... If the jury is true and accurate and doing what they're supposed to do, they have no idea what's going on the outside world. No idea. So whatever the media is talking about has nothing. It has nothing to do with what the jury's going to look at. Everybody knows about this, even before the trial. Come on, there. Are we gonna watch the rest of this? Then I'm gonna call it a day for a little bit.
Jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet and still, that was denied. It's impossible for impartial jury to be found in this county, and that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That would be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too. Family too, loved ones too.
That are still alive.
That also have been ridiculed and had their names drugged to the mud and have threats towards them. Loved ones that had to leave their home because they were getting threats thrown through their mailbox.
Mm-hmm. No, they weren't.
Children that didn't feel safe going to school because they were getting bullied behind what was being said.
Mm-hmm.
And that's not to sweep anything under the rug
I don't think any of your kids have your last name.
whatsoever.
Kids you don't even see.
To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy, definite. And that will never be swept under the rug.
Mm-hmm.
There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about.
They got nothing to do with this trial.
And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive, and it's not true.
It is true. You ran over all those people. That's true. You did. You ran over them people.
I'm sure the court read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions, I think it was obvious that the venue should have been changed. Obvious.
Mm-hmm. Very obvious.
It's too many connections and it's too close. It's too close.
Close to what? Too close, Darryl. It's too close.
If there was any chance for a fair trial and an impartial jury, it should not have been in this county.
Okay.
But yet it was denied without any validity.
Mm-hmm.
Zero. There's so much bias that's going on that and even with all this, for the record, we still have no proof of jurisdiction.
Mm-hmm. You don't need it.
We still have no bond on file
Don't need it. You didn't
in the
qualify.
docket sheet.
None of that's going to save you, Darryl.
We still have no plaintiff. We still have no claim.
False and false. You have both. How can a dead person make
We're
a
not
claim?
sure of the relationship between you, Your Honor, and a father of one of the people that was injured.
Mm-hmm. What's that got to do
We're
with
not
anything?
clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech. That was obvious.
So what?
Where's the proof? I just
So
asked
what,
that
Darryl?
same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case. There's no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response. Go ahead.
Thank you, Judge. Judge, I'm going to summarize
We'll
what I
listen to
just
this.
heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last one?
I'm so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. And the court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a Seventh Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly
To be called that name, nor do I know any individual by that name, Your Honor.
Please do the courtesy of not interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial.
That's true.
He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the state, the knowledge of the law, his ignorance of the law. And his words to this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator, if he accused this court of treason.
He did.
But I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn. At every turn.
It's true. They have been, actually.
I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial. And on the other hand, we're rushing him to this case and he hasn't had adequate time to prepare. He is
Anyways, that's about it, guys. I just wanted to share that little bit of this
denied
Darryl Brooks
access
deal.
to legal materials in
Because,
the jail.
you know, some of what Alec Baldwin's attorneys were referencing kind of made me think of this. So I'm going to get out of here. I'll be back at 8 o'clock tonight with a normal flight. You know, maybe not a normal flight, but normal time for normal shit that we normally do. So please hit that subscribe button, hit that like button. If there's something you'd like to see that, you know, you want me to comment on, let me know. I'll certainly do my best to do it while I'm in between jobs at the moment. And that's about it, my friends. Super chat, super thanks. Get a membership. Tell your friends about us. Tell your family about us. Tell everybody about us. I will see you in a few hours, my friends, on the next episode of the All About Aviation show on the network. The network of me. The US network. The US network.